Criminal Appeals is now back in session. You may be seated.
Thank you, Madam Clerk. I think everybody was in here when we started this morning, so just in case, Appellant, if you want to reserve any time, please let us know at the beginning. Everybody has 20 minutes aside. Call the next case, please.
State of Tennessee versus Mitchell Hopkins.
Good morning, Your Honors, opposing counsel, and may it please the court. My name is Josie Holland, and I represent the appellant Mitchell Hopkins by appointment. I'd like to reserve 4 minutes for rebuttal, please.
Okay.
Appellant's argument today will first focus on the Bruton issue as it arises from a jail phone call from Jarrell Anderson to Jerry Anderson. And then we will turn to the issue of the late disclosed enhanced video, and then finally the issue of insufficiency of evidence if we should have time. Turning first to the Bruton issue. This matter, Your Honors, was about a suspiciously timed jail phone call from Jarrell Anderson to Jerry Anderson. This phone call was one of the state's key pieces in connecting Mitchell Hopkins to the offenses considered in the case. So what happens is that there is a jail phone call made from one of the brothers, from Jarrell to Jerry, and the state asked to play it during trial. And several redactions are made from the video call, several identifying redactions are made, and then it's taken to the stand where Jerry is on direct. So what happens in this phone call? I believe in the state's...
Before you get there, counsel, I was a little unclear from the briefing, but it said the state agreed to the redactions. Was that, was an objection made by the defendant, and then in the alternative, an agreement to the redactions?
Yes, Your Honor. There was, so the defense objected to the phone call, asked for severance, and then they, in the alternative, agreed to make these redactions to the video, to the audio. So the audio is played during direct examination, and this happens with ADA Chris Laro. Now, I would like to say something that I think might be a little unusual for these arguments. I've known Chris Laro for 10 years. He is a kind, compassionate, and collegial adversary, and it brings me no pleasure to say that he made a mistake here, but he did. He made a mistake, and it affected the Sixth Amendment constitutional rights of Mitchell Hopkins. And that is because during the audio call, he asks Mr. Anderson to clarify what he means when he says they supposed to be starting shooting first. So and Mr. Anderson then says, oh, blue, when he called back, and then he stops himself and he says, Mitchell, when he called back. So Jerry identifies Jarrell's statement of identification as being both Blue and Mitchell. Okay, Bruton tells us that the identifying statements of a non-testifying co-defendant should not come in, that is violative.
The state, if I understand the state's brief correctly, the state argues that Blue and the defendant were never connected until cross-examination by either your client or one of the co-defendants. Is that correct?
I must respectfully disagree. That is not correct. Volume 7, page 541, somewhere in the general vicinity of lines 15 and 16, Jerry starts to say, as he's trying to clarify who Jarrell is referring to in the video, in the audio, my apologies, who Jarrell is referring to in the audio. He first says Blue when he called back, Mitchell when he called back. And I believe the state's argument is at that point that the jury may not know that Blue and Mitchell are one and the same person, but it seems to be a correction that he's making as he's testifying, because the idea is that the Anderson brothers are trying to implicate Blue or Mitchell as the person who instigated the offense, who the person who called them over for the shootings, the person who was the leader in the offense. And this was a problem. This is non-structural constitutional error.
So let's assume that your reading is the correct reading, that he said Blue and then he said Mitchell, and the jury knew at that moment that Blue and Mitchell are the same. That's really the only mention of your client during those phone calls. Everything else connecting your client to this crime is outside of those phone calls, correct? You don't have a Bruton problem anywhere else other than that little
Yes,
statement is my
yes,
point.
Your
Like,
Honor.
everything else connecting your client to this crime, whether you agree there's sufficient evidence or not, but everything else connecting your client to this crime is outside of those phone calls.
That's true, Your Honor.
And also, as the state points out, the trial court instructed the jury at the end of the trial. Each defendant has to be judged on their own, correct?
Correct.
So if you have this one misstatement by this defendant that's quick, I recognize you're going to say it's the end of the world, but I mean, it's quick, and nothing else in that phone call ties your client to the phone call, to the nickname, to anything else, and everything's outside of that, and you have an instruction. Is it really reversible error?
It is reversible error, Your Honor, and that's because of the weakness of the proof. And I think if we look at State versus Ogle, and then Deli Paoli is the federal case. I'm probably butchering the pronunciation of that. We're going to look at a couple of factors. So I think it was in Paoli, they said, well, there was a jury instruction, and all of the other proof was really overwhelming. And in this situation, when we do have a jury instruction, some situations present prospects of prejudice so untenable that they cannot be left to the jury, even with a curative instruction. But there are a lot of jury instructions in this case, and it's sort of buried in there, and so that presents a problem. And then the other proof is simply not overwhelming.
Yeah, I mean, I get your argument about there's tons of jury instructions, but the law is pretty clear, you know, whether you agree with it or not, whether I agree with it or not, whether anybody agrees with it or not, that, hey, we presume the jury follows every word in those jury instructions.
Well, I must counter, Your Honor. Bruton is pretty clear. It's a very bright line rule that we do not name the defendant, that even if we have statements of a non-testifying co-defendant where the defendant his name is redacted and left as a blank, and even though it can be very apparent about who the non-testifying co-defendant is speaking about, as long as the name is not said, we don't violate Bruton. But in this situation, we have a problem.
And that goes back to my point. So even if I read the transcript the same way you do, that he said Blue, Mitchell called, the state's argument really is that no one actually said Blue and Mitchell are the same person until it was brought out on cross-examination. The state didn't bring it out. And so do you have a Bruton problem if it's not brought out until cross-examination by the defendant?
Well, it's the state asking the question on page 541 where he says the name Blue and Mitchell. So I respectfully must disagree with Your Honor that the defendant is who brought out the name or who made that connection for the jury. And since this is a non-structural constitutional error, it is the state's burden to prove that the error did not contribute to the verdict obtained, and that is whether it appears beyond a reasonable doubt that the error complained of did not contribute to the verdict, and that's State versus Rice. So, turning to the question of the video, the trial court abused its discretion when it improperly admitted a previously undisclosed enhanced video into evidence. Here, the advanced video created the impermissible and unwarranted suggestion that Mr. Hopkins' photograph matched one of the individuals captured on grainy surveillance footage. Since the video was late disclosed, Mr. Hopkins could not have the footage evaluated by an expert. He could not have an expert evaluate the moving footage. He could not have an expert evaluate the picture that was placed up there. And it's sort of a 80s freeze frame almost.
Well, he had access to the video before that, didn't he?
He had access to the grainy surveillance footage.
And didn't hire or employ an expert to do it his own enhancement, maybe to his favor?
He did not hire an expert to do an enhancement to his favor, but I think what we run into there is a question of burden shifting, right? Defense is relying on the fact that this video is very grainy, that no one's going to be able to make out the identification because of the quality of the video. And certainly, this individual who does have some discrepancies between Mr. Hopkins' appearance and what appeared on the video, he was relying in some ways on the fact that the video was grainy and the fact that an identification could not be made. And so to come in on the morning of trial and hear, oh, we've created this freeze frame version of the video with software that Hollywood uses, that approaches prejudice if it does not actually reach it. The video that was provided to the defense, it didn't allow them time to investigate. There was a problem with the timestamp. There was a problem with the address entered as it appeared. But then rather than be permitted to use an overly fancy visual demonstrative at such a late hour, the trial court could have employed less technical means that would not have prejudiced the defendant. They simply could have had a picture of Mr. Hopkins, even a blown-up picture just in the courtroom that could have been compared against the footage. That would have been totally permissible by the state, and probably what the defense was expecting in terms of trial strategy. And it is the impact of trial strategy, Your Honors, that makes this particular evidentiary ruling so problematic. It's the late hour at which it was disclosed, it's the high-tech nature, the additional resources that, of course, the state has in the face of and against the defense. It's not as if the defendant could say, okay, well, we've got this enhanced video, let me run to my video department and give it to them.
Did you ask for continuance?
Mr. McCluskey did ask for a continuance, yes, Your Honor, he did.
Who did he represent?
He represented Mitchell Hopkins at the trial level.
I was trying to remember who represented who at the trial.
Yes, Your Honor. So Mitchell Hopkins asked for the continuance. That probably would have been the better way to say that. Okay. And then the evidence is insufficient as a matter of law. Of course, LaRonda Turner and Tony Thomas was decided by our state Supreme Court in March of last year, which abrogated the accomplice corroboration rule. But the abrogation wasn't to take effect until 10 days after the order from the Tennessee Supreme Court, so this case falls within the realm of the cases that were still operating under the old rule. It is our contention, Your Honors, that the evidence is insufficient to support a testifying accomplice's assertion that Mr. Hopkins was there. Of course, there is the video, but beyond the video, there is sort of a gap, a question as to what the other corroborating evidence would be. Whether or not the video rises to the level of a scintilla, I will leave that to this court to decide.
Well, scintilla is pretty small.
It's pretty small.
Scintilla is very small, Your Honor. In consideration of the foregoing errors, the trial court, this is the Bruton problem, which is our biggest issue. It is a constitutional issue that one cannot say is harmless, and certainly the state, who has the burden of proving its harmlessness beyond a reasonable doubt, cannot point to evidence which indicates that it is harmless. The trial court abused its discretion by admitting the late disclosed enhanced.
I want to ask one more question about
Certainly.
the video, Judge Campbell's question about the continuance. But you learned of the video a week before trial, but you don't raise the issue until the day of trial. I mean, why didn't you file a motion immediately, go to the trial court immediately and say, this is a problem? I mean, you wait till the day of trial to ask for a continuance when you had it at least a week before, the enhanced video, at least a week before trial.
That does raise a question as to why someone might not approach the judge the Friday before trial and say, we have a problem here. I
don't have the dates. All I
unsure-
just know is it said, the state can clear it up for me as well, but it says that their argument is you had it a week before trial, not the week as in the Friday before, but a week before trial, you had it and you wait until the day of trial to ask for continuance.
I would say, Your Honor, that the case was not set on those days, and thus the continuance could only be asked for on the day that it was set. But as I was appointed on appeal, the timeline for the disclosure of the video and the timeline for the continuance is not something that.
Are you saying, I understand.
I understand Your
Are
Honor's
you saying though,
concern.
I want to make sure I understand a statement you just made. Are you saying you have to have a case on the docket in order to approach the trial judge about a case that is on his docket later on?
No, Your Honor, I'm
Okay.
not saying that. I'm merely trying to provide a reasonable explanation for why my colleague at the lower level may have made the decision that he did.
Let me ask you this. At motion for new trial, did you put any proof on to establish what could have been done had a continuance been granted, and who could have, what could have been done as far as looking at the video from the defense's side?
Unfortunately, Your Honor, appellant did not provide that proof at the motion for new trial. Seeing that my time is running out, I would ask Your Honors to find that this was an error worthy of reversal, to set the judgments aside, and to remand this case for a new trial. Thank you.
Thank you.
May it please the court, Kirby May, on behalf of the state of Tennessee, and I'd ask this court to affirm the judgments of the trial court and affirm the verdict. The defense is, and I'll address the issues as the defense has in regards to the Bruton issue. As Ms. Holland referenced, the jail phone calls that were referenced occurred between jury selection and the night before testimony. And those calls were between Gerald, who was a defendant that was at trial, along with Mr. Hatch, and along with the defendant at trial, to Jerry Anderson, who was his brother, but also a defendant who was cooperating, and not at trial, but a cooperating witness. The state provided those phone calls that morning. There was a thorough jury out hearing regarding the phone calls. They were actually played for the court, and the court allowed to listen to the unredacted versions of it. And Mr. Hopkins, as well as the other defense attorneys, objected to the references to the other defendants on trial outside of the two brothers, Gerald and Jerry. The court made reference to, was concerned about the Bruton issues, and the parties were sent to review and see if there was a possibility of redaction. The parties did redact, and I'll be very clear that even once returning to court, Mr. McCluskey, who was representing Mr. Hopkins, continued his objection as to even the redacted version. So I'll be clear that he didn't just concede the redacted versions were appropriate. But the redactions at that point removed all references in the jail phone calls that were presented to the jury to any of the other defendants, including the defendant here today.
I guess it was, when I was reading this, it was my understanding that the redacted audio didn't reference names.
At all.
Okay. It was when the examination of the witness occurred that this blue came up.
Yes, Your Honor, and that's why I wanted to distinguish between the jail phone call Bruton issue that they raised, as well as then it's a separate issue as to the concern of the Bruton issue as to Mr. Jerry Anderson's comment. And so the state presents that the trial court did not err, and that it was well within its reasoning to permit the redacted jail phone calls. Now, as to, and those phone calls, there was, again, no reference to the other co-defendants by name at all, and the portions were played and are referenced in the transcripts. All the proof in that goes against Gerald. But that there was a shooting, to corroborate that there was shooting, that Gerald participated in the shooting, and that others vaguely referenced participated, but no names. The state will disagree with Ms. Holland's interpretation of the transcripts, and that the reference to the transcripts, it's during the playing of the portions of the transcript through Jerry Anderson that this comment comes up. And it was not a comment in response to the prosecutor's question. It was a sort of a non-responsive comment. And the exact comment it's in volume 7, page 541. But to get the context, you have to look through about 530, about 555 is when, but the comment, the question before was when you said they supposed to be starting shooting first, so when he told them to come over, and this is the comment is that Gerald is making the comment that he told them to come over, and then Mr. Anderson, Jerry Anderson, interrupted and said blue when he called, Mitchell when he called back. And then there was an immediate objection by Mr. McCluskey. And at that point, the jury is removed, and they had a conference between counsels and the court, and there was lengthy discussions of what had happened and what understanding that the jury would have to that simple reference of Blue and Mitchell, because there wasn't any other context of what Blue or Mitchell, who that was, or what that context was because of the immediate objection. And the court was very clear that the jury would have no reference to this with the immediate objection and with the jury instruction, the security instruction to tell the jury to disregard that. And so from there, the only reference connecting who Blue was or any other connection to that was when Mr. McCluskey cross-examined Mr. Jerry Anderson and went into the fact that there was an allegation of an ongoing dispute of why he's putting Mr. Mitchell into this incident. If I remember correctly, Mr. Jerry Anderson was a rap recording studio or something, and there was some song that he was involved with that made reference to Blue, not to Mitchell specifically, but to Blue, and that to doing harm. But there's no time frame of was this before the shooting, during the investigation, or subsequently. There's not really a reference to the timing of it, but that was the defense impeachment of Jerry Anderson.
Did anybody ever testify Blue and Mitchell are the same person?
Through the cross-examination of Jerry Anderson by Mr. Mitchell's attorney. That was the connection to that. Mr. Anderson was asked specifically, something along the lines of, does Mr. Mitchell go by the name Blue? And then there was about 2 other names, Blue something. There were about 3 names. That was the connection at that point.
Okay.
But so it's the state's position the trial court did not err, and that the defense was not prejudiced by that simple reference, and due to the curative instruction.
So when the trial court made the statement, it's in the briefs, but the objection was made and the court said nothing's happened yet.
Yes.
Okay, that was the Blue Mitchell situation. Okay, and then later the cross-examination happens. Okay, but no other attention to Blue.
No.
Nothing in the argument at the end, anything like that.
Well, no, I'm not saying, I don't recall the exact arguments at the closing arguments,
Okay.
whether the reference, I won't say that did not occur.
Right.
But it's saying through testimony and evidence that was presented at trial, that was the only time that reference to Blue and Mitchell was put together.
Okay.
And it was put together under examination by the defense counsel, Mitchell's defense counsel.
Mitchell's defense counsel, precisely.
Did the rap song call out I mean, was that the song that he had called out Blue to do him harm?
Yes, but there wasn't a reference to the timing of it. But that was the cross-examination. Mr. McCluskey set it up by asking Mr. Jerry Anderson, does Mr. Mitchell go by these nicknames?
Okay.
And then the rap song was never played, but there was cross-examination. Were you involved with making a rap song that included doing harm, either shooting or killing? It was something along those lines to a Blue and maybe those nicknames. The song was never played, but that was the style and the theory of the cross-examination that was used by Mr. Mitchell's attorney. Now to the compilation video. Each item that's in the video, the compilation video that was introduced, were previously disclosed to the defense counsel through discovery.
Including the enhanced picture?
Well, no, the items themselves. What was included, and I think it's exhibit 34 or 35, was the compilation video. But each of the exhibits that built up to it were included, which include the 911 call, the Ring doorbell camera, as well as the convenience store camera, as well as the eventual camera from the apartment complex, as well as a map that was overlay to give the general distance from the locations of the apartment complex and where the shooting scene happened, the two drive-by shootings. And then added to it, so all those items individually themselves were introduced through without objection, not a single objection to any one of those individual items. And that was all provided in discovery. The original version, non-enhanced version of this compilation video, which all it was streaming the video in a time sequence, so you just see portion to portion to portion as the events went on, was provided to the defense, according to the record, 10 months in advance. A week in advance, that's the testimony. It doesn't say exact days, it said a week, and that was the testimony from the parties. The enhanced version was provided. And the difference between the original version and the enhanced version is the two photographs, again, not objected to. One was of one of the other defendants on trial, and one was of Mr. Mitchell. Mr. Mitchell, it's a picture that Jerry Anderson testified to and identifies a picture of Mr. Mitchell standing in front of Mr. Jerry Anderson's own car, which is also one of the vehicles that was involved. And another picture was just a Facebook picture of Mr. Hatch, which, again, not really relevant to this case. But those two pictures, what happens in the video is Rebecca Gross, the digital analyst for the district attorney's office, pause the video as it's going through. When we're talking about the apartment complex, really, pauses it, and then juxtaposes the picture of the defendant next to the paused version of what's the state's theory was the defendant, and then another pause with Mr. Hatch with his photo, all of which was testified to.
So is it truly an enhanced? So this is where I'm confused. Is it a technologically enhanced picture that's a screenshot from the Ring or whatever you want to say, where they've enhanced it to make it more clear?
No.
Or is it really, because the other term that was used in the briefs was a zoom in. Is it really just a zoom in on the same grainy picture that they had beforehand? You've just cropped it differently.
Basically, Your Honor, you're very correct. It is, once you get to see it, it's a zoom, and the state will disagree. It wasn't a blurry video that many of you have seen in the past as trial attorneys in the past. It was actually better than blurry, but still, it's a distant video, and it's paused, zoomed in, so it's even more blurry, and then, but you can get the physical dimensions of the individual and the clothing, and the picture juxtaposed next to it. That's all this is, a pause and a zooming in. And the trial court made a very specific finding, that's all it was. While the defense raised issues saying that it was Hollywood magic, there was no...
So the term enhanced is a bit of a misnomer here.
Yeah, that's the state's position. It was a pausing and a zooming in. And one, Your Honors, mentioned this in your comments, that this would be nothing, there was no prejudice shown from the testimony. At the motion for new trial, they did not present an expert saying this is how it was altered, this is how it prejudiced. It was just argument. And the state's position that it did not occur that way, and the trial court did not err, and was within its discretion to allow that to be admissible, because it was more of a discovery issue and a motion in limine than anything else in regards to that. I believe my time is almost up, but and then in regards to the sufficiency of the evidence, the defense does not dispute that this incident occurred. It's clearly on videos. The defense sole argument is that whether the state sufficiently proved identity. And in regards to this, again, this is pre-Thomas, and it goes on the modicum of proof, and significant evidence is not required in this instance. The additional evidence that was presented was that beyond Jerry Anderson testifying, you had Sergeant Phillips who testified about interviewing all the individuals that they did, and then taking that information, looking at a database, finding, because they had the named individuals, Mr. Mitchell and the other defendant, and looking at pictures, going, these are the same individuals. Then there was the officers identified them in courtroom. Those photographs, additional photographs were identified and admitted without objection. And then another aspect of the trial was each defendant was stood, the video was presented, and then the three defendants on trial were stood into positions demonstratively in the positions they were on the video. And so the jury was able to take all those things, the photographs that were introduced, the videos that were introduced, the testimony of Sergeant Phillips, that's what was used and more than sufficiently corroborated the identity of the defendant's role in this in the drive-by shooting. And taken also from grain of salt in regards to this, the jury acquitted the defendant of his role, of any role in the second shooting. There were two shootings, one at 3 p.m., 2 to 3 p.m., one at 6 p.m. Even though Jerry Anderson did testify that the defendant was involved in both shootings, Sergeant Phillips testified, based on his review of the video and the evidence, he was not. And the jury acquitted the defendant of the second incident, of the second drive-by. The state would ask your honors to affirm the judgments of the trial court and find that the evidence is sufficient to corroborate. And thank you.
Thank you. Ms. Holland, your rebuttal.
Thank you, Your Honors. The appellant would respectfully take umbrage with the idea that the defense is at fault for connecting the nickname Blue to the name Mitchell.
Well, did it come out during cross-examination?
It did come out during cross-examination, Your Honor, but Jerry was always going to testify that Mitchell was present at the shootings. The idea that the nicknames would not have been connected anywhere but cross-examination is...
Okay, so if they, again, shouldn't the defense then be very careful about how they crossed if they didn't want this name to come out?
The name had already come out at that point.
Well, but the jury was told that it hadn't been linked to the defendant.
It hadn't been linked to the defendant before the jury in the proof, Your Honor, but it was always going to be...
What I mean is, what you're saying is, you were saying that there was a violation, and you were blaming the state for saying, oh, we're linking Blue with the defendant. But it's, when I was looking through this, it looked like it was the defense lawyer that actually connected that.
Well, when Jerry testifies, he does actually say Blue and Mitchell. He does testify.
I know that, but at that point in time, nobody knew, the jury didn't know who Blue and Mitchell were, or that they were the same person.
But it would have become apparent to the jury that Mitchell and Blue were the same individual. I guess what Your Honor is saying is that the state never affirmatively said,
How would it become apparent to the jury that Blue and Mitchell were the same person without questioning from defense counsel? Because defense counsel is the one that said, doesn't he go by the name Blue whatever? I mean, where else in the trial would I think this is what Judge Campbell was trying to get at, where else in the trial would that have come out without that questioning?
In Hot Boy's testimony about Blue/Mitchell crying about the baby being shot, there was testimony that there was a small child who was injured in the shooting, and that child was like Blue or like Mitchell's baby, and that Mitchell/Blue had cried after the shooting. That was Hot Boy's information, and I believe that did come out later in the trial.
Okay.
So
Later-
that was connected there.
Let me ask a qualifying question, what you mean by later. Did that come out later after defense counsel had already gotten the witness to say Blue and Mitchell, or did it come out before defense counsel asked, are Blue and Mitchell the same person?
It would have come out after that cross-examination.
Well, so then, at that point, defense counsel's already put it out there. The state didn't put it out there, defense counsel put it out there. I think, is that?
I believe, Your Honor, and if I may just answer this question before we're gone. The defense had a very specific strategy that they had intended to employ, and it involved the use of the rapper name Blue. And when Mr. McCluskey moved for severance, when he moved for a mistrial, it was based on the fact that his entire case's defense had been constructed around identifying Mitchell as Blue. And so that was why he moved for severance. That was why he moved for the mistrial, because he couldn't, at that point, go back on the strategy which he had already intended to employ. And by requiring him to do that based on the state's constitutional error, that really robs him of his ability to construct a defense. And the better move would have been to just sever these defendants, and then it all could have come out. But in the name of efficiency, they were combined and the trials were heard.
I know your time's up, but I do have one question based on the statement you just made. Is all of that Mr. McCluskey had this defense strategy concerning the name Blue, is that all as part of his objection in the record as to why he wanted a severance?
It is, Your
Okay.
Honor.
Thank you.
Thank you so much. We ask for your reverse. Thank you.
Okay, thank you. Call the next case, please.